Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of criminal procedure, that too in relation to joint trial matters. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hello everyone, I am Advocate Shweta Singh. Today we are discussing an important judgment titled Ms. P1 versus State of Uttarakhand and Another, pronounced on 16th June 2022. The Supreme Court has held that whether two or more acts constitute the same transaction for the purpose of being tried together under section 220 of the Code of Criminal Procedure is purely a question of fact. The reasonable determination of the same would, however, depend on elements like proximity of time, unity or proximity of place, continuity of action, and community of purpose or design. The facts of the case would be that FIR came to be registered against respondent number 2, the accused, and after investigation, a charge sheet was submitted for offences under sections 376, 504 and 506 of IPC. And in view of the involvement of offence under sections 376 of IPC, the case was committed to the Court of Sessions Judge, who held that the offence under section 376 of IPC, which took place at Delhi, was not a continuing one. And whatever threat was allegedly given by the accused to the victim, it did not constitute a kind of offence which could be said to be in the series of same transaction. Therefore, the accused was entitled to be discharged in relation to the offence under section 376 of IPC for want of territorial jurisdiction. And in sequel, it is just and proper to remit the matter to the judicial magistrate for trial of the remaining offences pertaining to sections 504 and 506 of IPC. The order aforesaid was challenged by the appellant in the criminal revision petition before the High Court, which declined to interfere with the order passed by the Sessions Judge discharging the accused from the offence under section 376 of Indian Penal Code. Being aggrieved, the present appeal has been filed with allegation that the accused was wrongly discharged of the offence under section 376 of IPC without the Sessions Judge appreciating that the offences forming the part of the same transaction could not have been segregated on the ground of want of territorial jurisdiction. The counsel for the accused argued that in terms of section 218 of CRPC, the Sessions Judge rightly ordered for separation of charge in relation to section 376 of IPC and rightly not proceeded with the same for the alleged occurrence having taken place at Delhi. The issue posed for the consideration is that whether the allegations against the accused of committing rape, hurling abuses and extending threats respectively pertaining to offences under sections 376, 504 and 506 of IPC could be said to be one series of acts so connected together as to form the same transaction for the purpose of trial together in terms of section 220 of CRPC. The Supreme Court has held that the fact situation of the present case and the complaint as made by the appellant is of the allegations of different offences of different nature and at different places of occurrence, though said to have been committed by the same person, the accused, and against the same person, the appellant, and having their genesis in the proposed matrimonial alliance which did not materialize. The allegations obviously consist of offences of distinct nature inasmuch as one set of allegations is of the offence of rape at Delhi and the other set of allegations is of hurling abuses and extending threat on phone calls received by the appellant at her village in district Chamoli. These being different offences, the question to be examined with reference to section 220 CRPC, read with section 184 CRPC is as to whether the alleged offences are such that the accused could be charged with and tried at one trial for each of them. In other words, as noticed, the question in this case is as to whether the acts complained of could be said to be one series of acts so connected together as to form the same transaction for the purpose of trial together. A close look at the alleged events acts bring to force the basic feature that the appellant and the accused were engaged for matrimonial alliance at their village, but the proposal of marriage did not materialize. However, the alleged acts of sexual relationship took place at Delhi. The other alleged acts were of the accused hurling abuses and extending threats which the appellant received over telephone at her village. The acts in question were neither proximate in time nor proximate in place. They were not of continuity either. Significantly, while the appellant alleged that she submitted to the sexual acts because of the threat by the accused to snap the proposed alliance, but it had not been her case that the accused attempted to coerce her into the same physical relationship while hurling abuses or threatening to kill at the later part of time. Thus, it is difficult to find continuity of actions and community of purpose or design in two different acts leading to two different set of offences. Putting it differently, so far as the act leading to the offence of rape under section 376 of IPC is concerned, even as per the allegation of the appellant, that particular act was a completed one and the original design of subjecting the appellant to physical relations was accomplished at Delhi. As noticed, there is no allegation of such an activity having continued later or having taken place at Chamoli, or even any threat having been extended to the appellant to again submit to such an activity. Viewed from this angle too, the completed act concerning one offence under section 376 of IPC could not have been connected with the other acts leading to other offences. Thus, the two alleged set of acts, one of sexual exploitation leading to the offence of rape and another of hurling abuses and threats leading to the offences of insult and intimidation, are just like chalk and cheese. They cannot be connected together so as to form the same transaction on the facts of this case. Further, the accused having gone through the trial in relation to offences under section 504 and 506 of IPC and having been acquitted cannot be subjected to another trial for the same charges on the same facts. Any such process would be in blatant disregard of the settled principles which disapprove double jeopardy and are precisely contained in Article 20 of the Constitution of India, as also Section 300 of the CRPC. On the facts and in the circumstances of present case, even if the accused is acquitted of charges under sections 504 and 506 of IPC, he could be tried by the jurisdictional session court in respect of alleged offence of rape under section 376 of IPC, because this offence could not have been tried by the judicial magistrate. However, he cannot be sent to trial again for offences under section 504 and 506 of IPC in any event. Upshot of the foregoing discussion is that on the facts and in the circumstances of this case, the alleged offence under section 376 of IPC and other offences under sections 504 and 506 of IPC do not fall within the ambit of one series of acts so connected together as to form the same transaction for the purpose of trial together in terms of section 220 of CRPC. Thus, the sessions judge rightly discharged the accused of the offence under section 376 of IPC for want of territorial jurisdiction.